Good morning. It's great to see everyone here. Really delighted to be here with this august crew to talk about these very important topics. My name is Jonathan Gould. I'm on the faculty here at Berkeley Law, where I work on constitutional law and a variety of public law topics. I will give brief introductions. We could do the 2 hours on the resumes of the people up here with me, but we will not. So I'll give very brief introductions, and then we'll go down the line from David to Joey. And then we'll open it up to discussion. And each of us up here will talk for no more than 10 minutes, hopefully in the 8 or 9 minute range. And then we'll give Joey the chance to respond, and then we'll open. So David Graywall teaches here at UC Berkeley, is a lawyer and political theorist, is one of the kind of leading lights of LPE, law and political economy, and has given a great deal of thought to these questions from both contemporary and historical perspective. Paul Pearson teaches in political science here at Berkeley, is one of our most astute thinkers about American politics, especially as an observer of the pro-oligarchy side of American politics, thinking about the political dynamics of the American right among many other topics. Dirk Hartog is Dirk Hartog is a legal historian from Princeton, who I have not met, which is perhaps cause for the mispronunciation, but I've been reading for many years, and has written on virtually everything from federal power to property to slavery. Angela Harris is a law professor at UC Davis, works on issues of identity and in particular of race, which are of course key parts of the story. And Joey Fishkin is a law professor at UCLA and is here in his capacity as half of the Fishkin and Forbath duo that are the occasion for this gathering. So really thrilled to be up here with this group. David, why don't you kick us off, and then we'll go down the line. I'm happy to start if my senior colleague yields the floor. I'm happy to start. So I think I had occasion to think about some of these issues in print, in person, and I think one way of segmenting the story is there's a story about constitutional institutions and there's a story about constitutional argument. And the story about institutional institutions is one that I think will be familiar to many in this room, and one where I think Fishkin and Forbath would add their voice, is one about critiquing our system of campaign finance, the structure of the Senate, the structure of the Electoral College, a number of the kind of familiar structural features of the constitutional order that are now often seen as bad for small d democracy and as bad for big D Democrats. The role of judicial review in this story is sort of the elephant in the room, and I'm fairly certain the book does not come out with a definitive thumbs up or thumbs down on the, but we can talk more about that. But this question of structures I take to be one of 2 important pillars of the conversation. How do we organize our government? Some of that organization is big C constitutional. Some of that organization is kind of small c constitutional in terms of framework statutes and congressional rules and norms and practices. So that's kind of one pillar, is the structural. The other pillar is the argumentative, that once we're out there doing politics within whatever structures we have, what sorts of arguments do we make? If we want to defend labor unions or affirmative action or a wealth tax, how do we do it? Do we do it on the basis of this is what the Constitution requires? Do we do it on the basis of conceptions of fairness and justice? Do we do it on the basis of a thick conception of equality, on the basis of economic arguments? There are a lot of different arguments we can make. And what I take to be the core normative argument of the book, as distinct from its really kind of glorious historical retelling, is that we ought reclaim this mode of normative constitutional argument. That when we're arguing for those things I just mentioned, there is a value to arguing for them in constitutional, as opposed to just as requirements of justice, fairness, economic efficiency, or whatever else. So that's the claim that I think is worth thinking about and probing more. And let me just say a word or two on ways into this. One is this question of who is the audience? That who are we making these arguments for? And the 3 audiences that come to mind are: 1, we could be making them for courts. 2, we could be making them for policy elites, most notably members of Congress, but also folks in this room, folks who work at federal agencies, journalists, and others. Or three, we could be making them for the mass public, trying to convince the American people. And I think there are different pros and cons of different types of constitutional argument, of different types of argument for each of those audiences. But I just want to suggest it is not obvious to me that constitutional argument is always the winning. That if you want to convince the American people the Supreme Court was wrong to do away with the right to an abortion in Dobbs, maybe people will be persuaded by the penumbras and emanations, but I think it's more likely they'll be persuaded by stories about real people in the real world suffering. This decision is likely to come. This question of kind of, are constitutional arguments as powerful as other arguments? And when I say as powerful, there's both a kind of short-term, kind of in the sense of public opinion persuasion power, but then long-term, where do we want to move the conversation? So I think those types of questions are important. Many of them are empirical. I'm glad we have a political scientist because many of these questions are ones that I, as a law professor, don't feel like law professors or philosophers or historians necessarily have the full panoply of tools to answer, because they're significant empirical components. Two other points. One is that there is a potential tension between different progressive priorities. And one of the things that was both inspiring and question begging as I was reading the book is we have this seamless web where economic values and inclusion values and kind of a range of other progressive values seem to all be hand in glove with each other. But then I read the news and I see things like questions around, let's say, childcare requirements in the CHIPS Act, where it seems that certain types of economic imperatives and certain types of inclusion imperatives might be in tension with each other. There are ways to resolve that tension, but just wondering questions around this sort of tension. Final point is around the power of courts being largely the power to strike things down rather than to build things up. We have some counterexamples, things like state rights to an education are kind of a when the power of courts is the power to strike things down, that will typically favor the right, given that the left has a robust agenda of a social welfare state and redistribution and regulation. It will sometimes favor the left. I mean, think of cases like where the left is embracing civil libertarian ideas. If the right embraces a kind of muscular common good constitutionalism, we might feel good about a kind of more civil libertarian view on the left. But nonetheless, wondering, is there a mismatch, or kind of, is the left inherently disadvantaged in constitutional argument? Because for many Americans, constitutional argument means courts, even if it shouldn't, because certainly for the courts, constitutional argument means courts. And there is this kind of asymmetry in terms of who wants to build up. There's much more to say. Really delighted to have the opportunity to engage on these questions. And David, I'll turn to you and then Paul.
So I'll be brief. I wanted to thank both Willie and Joy for coming. I think I first started engaging substantively with the ideas of the book in 2015 at a conference in Texas on constitutionalism and inequality. And it's been wonderful to see how questions of political economy, constitutional argument have been woven together in this book, but also in a whole series of projects that have come out of this dynamic duo. So it's a pleasure to be here. Wanted to pick up on John's excellent opening remarks, because I think it's an interesting way of thinking about the book, of course, as he excellently summarized, and as I hope you all know, it calls for, this isn't precisely our language, but recovering a kind of constitutional imaginary. So this is sort of, I think a constitutional imaginary is sort of, it's not obviously big C constitutionalism, but it's maybe something more than small c constitutionalism. And so I want to sort of, or maybe it's a nuance on small c constitution. I want to think a little bit about what that is, and then while doing so, think about the question of audience that John said, and just to foreground the audience point. At the moment, if constitutionalism means the courts, we all know the issues there. I don't need to rehearse them. That said, there are people on the court and in the background, the philosophers, so to speak, of the current jurists, who have a vision of a constitutional imaginary that captures some elements, not all, and maybe fatally not all, but captures some elements of the political economy program. So when I was reading the book now, in light of the really radical shift on the court, You know, in 2015, it felt like the right was neoliberalism in effect, and that recovering from below constitutional imaginary that brought an egalitarian political economy back was an obvious move as a dialectical counter move. But now there's a further move, which is basically common good constitutionalism, which is where conservative or right-leaning jurists are taking seriously the problem in effect of the political economic requirements of social reproduction in that broadest sense. And there's a pushback against neoliberalism from a situated, grounded, common good sort of constitutionalism. This is the grounds on which some people have wondered whether there could, and what it would look like to be a sort of realignment of certain kinds of social conservatives. And so, you know, I don't know what the prospects for that are or whether it's desirable, but I just wanted to put that out there, that reading this book after, say, Adrian Vermeule's Common Good Constitutionalism feels different than reading this book before Adrian Vermeule's Common Good Constitutionalism, just to put that there. Let me turn back with, I won't take too much time, but I wanted to suggest that one way of getting at this is to think about what constitutional imagination and how fully legal, coded as legal, and therefore going through the courts it has to be, and how much it's part of a broader political culture. And if it's part of a broader political culture, what do we mean by politics? Why is it not just, in effect, arguments that we should make as first principled arguments about legislation law should take? And I can't help thinking a little bit when I think about that puzzle, which I take it was our part on this panel, to Joey's points earlier, about the difference between democratic Athens and Republican Rome as our two great exemplars before the American founding of sort of places where people thought, whether or not they were correct, that they had gotten a grip on their law. And I was thinking specifically about the Roman invention of jus. This is J-U-S or I-U-S, the particular kind of law that hovered above or in the background of all the formal legal determinations that the Romans made. Jus is not identical with statutory law. It's not identical with legislation. It's not identical. It's not a senatus consultus. It's not even mores maioris. It's not even the customary law. It was a law that jurists made up, and they started making it up because they were given the power to declare what the law was based on their assertion or their discovery of values. The opening lines of the digest, Ulpian describes jurists as priests. Sacerdotes, this is the opening line of the greatest book on law ever published. We are the sacerdotes of jus. We are the priests of this thing, this spectral presence of law, which he defines as, quote, an art of goodness and fairness. And it's based on a philosophy, he says, which, if I am not deceived, is genuine, not a sham. That's the opening of the digest. You don't need to read very much against the line to see what the people who are going to be trained up in Roman jus were being told in the first line of the digest. And later, the jurist Paul, one of the greatest jurists of Rome, he describes the locus, let's say the place of jus, as, quote, wherever the praetor has determined to exercise jurisdiction, having due regard to the majesty of his own imperium and to the customs of our ancestors, that place is correctly called jus. So you have this free-floating, jurist-made culture of law, which never needs to be quite written down, but can always be enacted. And as the empire grew, the role of jus as the way that you achieve social integration between people who have political rights and people who don't, becomes the central way that you manage an empire. Now, democratic Athens did things differently. In effect, what happened was that all these sort of jus-like forms in Athens, the nomoi of Athens, get directly politicized and put under the control of the demos, which means an assembly, an actual assembly of people determined what the law meant, in place of a priestly juristic class. Now, so there's two different models. Athens, as you know, is conquered from the outside, but its experiment of controlling its own laws goes forward. In Rome, what happens is that jus becomes such an important target because it's so powerful that efforts are made not to, so to speak, politicize it, but to make sure that it becomes representative. So the lower orders rise up, and at one point, for example, there's a famous steals the law books of the priests and opens them up to show the people what jus is so that they can sort of, to make it transparent. So there was transparency initiatives. There was then, in effect, inclusion initiatives where people from the lower orders would be put into the College of Pontiffs so that they could also decide what jus is. But throughout, the view was always that there was nevertheless this thing called jus, which had a certain technical, formal elaboration apart from politics. And then it became its own independent site of struggle, including distributive struggles. And so the question that leads me to thinking about constitutional imaginaries today is, do we want to go the route of Athens and try and grab this thing called the law and politicize? Or do we imagine that it's going to exist somehow above or outside politics, and our effort is to somehow make it more ours in an informalish sort of way? And the worry about the latter route, of course, is that it inevitably involves the sacerdotes of jus. Thank you.
Okay, I wanted to start by saying I'm really happy to be at the law school today, partly for the reasons that Larry alluded to, that there is this broad effort to try to reinvigorate political economy around the U.S., beyond the U.S. through the Hewlett Foundation's initiatives, including this new institute at Berkeley that I'm heading, the Berkeley Economy and Society Initiative, which is supposed to be an interdisciplinary scholars from across the campus together to talk about these issues, and the law school is very much part of that community that we really want to connect with. So I see this as kind of an opening opportunity to do some of that. And of course, I'm also delighted because it's really a terrific book, full of insights, sweeping, boldly, eloquently argued. I thought especially powerful in a searing and depressing portrait of the contemporary court's longstanding pursuit of a Lochnerian constitutional political. I've learned from every page, and I'm really grateful for having had the chance to read it. I'm also not a legal scholar. I'm a political scientist. I actually don't really like that label either. I feel like if you have to put science in your name, you're probably trying too hard. But I do come at it from a somewhat different perspective. And so I want to begin by saying something about an argument that the authors call profoundly wrong-headed, which is the alternative liberal strategy of de-emphasizing the Constitution. And I wouldn't go so far as to say that I want to advance that wrong-headed argument, but I at least want to explore it for a second and then turn to one other issue. So I think the central question for me that came out of this book was, is a focus on constitutional political economy the best power-building strategy for progressive economy? And so this comes back to some of the issues that John was raising when he was talking about the different audiences that we might care about and the arguments that might best appeal to those audiences. And I admit that I struggled a little bit in thinking the answer to that question, because even at the end of the book, it was a little unclear to me what constitutional political economy. There were times when I felt it meant smart political economy. So there are lots of times where I thought, like, oh yeah, that's the kind of political economy that thinks about these issues, particularly about the distribution of power, right? And how what we do is both affected by the distribution of power, that distribution of power. All right, so that's a very broad idea of what constitutional political economy is. I probably wouldn't call it constitutional political economy. There's a narrower version, which I think clearly has an important place in the conversations that we're trying to move forward, which involves developing good and persuasive legal arguments and never forgetting that you're crafting policies in the shadow of a hostile court. Right? And the authors have a lot of very interesting and important things to say about that kind of narrower version of constitutional political economy. But those questions, as important as they are, they're not always the overriding considerations in defining policy, or more important, in mobilizing support for policy. How do you, as Willie said this morning, win the hearts and minds of the people? Right? So when I approach these questions, I begin with the idea that the foundation for progressive economics is the accumulation of political power geared towards effective purpose. The anchor of a vibrant political economy is the understanding that policy is congealed power, right? That you need power to gain control over policy, and you should be designing policy in part, as conservatives have, in part with the idea that you are using it to generate more power for the things that you want to see happen and less power for the things that you don't want to see happen. Now, I don't think there's any reason to think that constitutional political economy is always the most effective framing for mobilizing people and getting those policies enacted. I think, and I hear also echoing something that John was saying, I think you actually would have to parse that quite a bit and think about what audience you're trying to reach and what's the most effective way of trying to communicate with them. And I'm not an expert on public opinion, but I share your basic instincts that often argumentation that is framed as constitutional argumentation is not going to be the most compelling. It's not going to be the most compelling to people. And one way I think to see that is to note something that I don't think we discuss enough, which is that there's been a pretty dramatic shift in economic policy views within the Democratic Party in the last 10 to 12 years, including right into the main corridors of political power in Washington. And you can look at issues like climate policy, industrial policy, concern about the care economy, changes in attitudes towards fiscal policy, antitrust policy. In all these areas, I think you see quite marked change. Hasn't always produced big changes in policy, right? In many cases, many cases, things have fallen short. But I think we often, as we're thinking about what the political moment looks like and where the opportunities are, we pay too much attention to Joe Manchin. I'm going to come back to the Senate again in a bit, and maybe not enough attention to recognizing how remarkable it is that there were probably 48 votes in the Senate for very expansive economic policy changes that were not even contemplated 10 or 15 years ago. Right? So there has been, and in all those areas, I would add, a much greater emphasis on issues of racial justice and worker solidarity, right, across all those domains that I was talking about. That's a pretty striking change. So far, it's generated some policy, not enough, right? But I think it's incumbent on us to try to figure out why that has happened, right, and how that process could be reinforced and accelerated. Is this a result of a resurgence in constitutional economy? I think the answer to that overall is would be no. That's not central to why that's happened. That's something that we could talk about. There are particular areas where I think it is central. Antitrust would be the one that I would say would be most prominent. But I think in a lot of these other areas, and one I've spent some time thinking about, which is really the remarkable growth of interest in the care, a huge hole in the American welfare state and American social provision, always, right? That the politics around that have changed dramatically, and I just don't think that that's come, it's come from other sources that we could try to discuss what they are. So that's the main thing I wanted to say, and now I've lost my notes, but I'll just make one other point briefly, which is that I thought there could have been more emphasis in this book on problems with the Constitution, which I think actually, though you said is one of the two main issues here. I don't think there is much discussion about the problems with the Constitution in this book. There are allusions at various points, but when I think about constitutional political economy, one thing that I would want to put front and center, and I think there's enormous evidence for this in the work of comparative political scientists, the American constitutional framework is actually not a design that is favorable to progressive economics. It is, in lots of its features, quite hostile to social democracy compared with the constitutions that exist in other countries. So I kind of read the book as saying, like, as the authors, they see a swan in waiting in the American Constitution. I would say, frankly, sometimes an ugly duckling is just an ugly duckling, right? And so when we think about the Constitution and where it fits into the kind of a world that we would like to see that is more favorable to economic justice, and I would say to actually producing genuine prosperity creating a more prosperous society. There are a lot of core structures in the Constitution that would look quite problematic and that should be, near the center of our conversations. An astonishingly malapportioned Senate, where that malapportionment now matters much more than it used to because of the way that the parties have aligned around urban and rural divides. A profoundly anti-democratic and antiquated electoral college, right? And if we wanted to think about why we have the kind of court that we have, we could stop right there, right? Without those two features, you wouldn't have a court that looks like this, right? A uniquely arduous amendment process that makes updating the Constitution for the modern era virtually impossible, and an extreme diffusion of political authority by comparative standards that, when combined with the intense and nationalized political polarization that we experience now, makes progressive economic governance extraordinarily difficult, and would actually make it extraordinarily difficult even in the absence of such a hostile Supreme Court. Right? So we need to pay attention to the Constitution. My guess is the authors don't disagree with me about this, but I think people who are thinking about the American Constitution and how it relates to what we want to do to the economy need to put issues of constitutional reform really at the heart of their intellectual.
Thanks. Can you hear me? Okay, good. So I'm really pleased with to sort of follow on this, because I think I grew up, and I still probably am, a Beardian on the Constitution. Not, and I think one of the parts of the book I would argue with most was the progressive era part, because I think so much of what I take from the progressives was disquiet about the Constitution rather than the embrace of the Constitution. And so much of the work of the legal realists was avoiding the Constitution because they saw its problems and they wanted to find ways around that in various different ways. I love the book. I think what Willie and Joey have done is to produce an equivalent of Pocock's republicanism in recovering a tradition in a way that's important and engaging with how it might have continued to have significance. I think that's, as a historian, an extraordinarily important thing to have done. So I want to celebrate that. In the middle of the night, thinking about what I should talk about, I woke up and I thought, and it connects to the notion of the constitutional imaginary. I want to make 2 points. One is about the problem of the great forgetting. What was the great forgetting? And I think that it's a little thin and it's a little court-centered, as it is right now. And the second is, who are our constitutional actors in the imaginary today? What do we mean by a political economy? And I think this connects also to Paul's point about the care economy. The care economy is a huge portion of what we mean by political economy today. And, the male autonomous worker is actually a bit player in the story of the care economy rather than what he was in the in the great work that Willie wrote a generation ago, or in the late 19th century story. When we think of who are the central constitutional actors today, both in legislation and in the court, they are children and the parent-child relationship. And then the care economy that builds around that. And so how that occurs, that's in a sense a different story than the one that the great tradition tells, but I think it's inescapably part of what we mean by a political economy today. So it raises a bunch of, quite concrete historical questions for me. One is, what is the relationship of the forgetting to caroling products? And how do we, because what do we mean by discrete and insular is deeply tied to notions of dependency, responsibility, care, how that should extend beyond the world we live in. And then I have a second historical question, which is, in that forgetting, one of the things, Willie and Joey were not writing a direct constitutional narrative of change, but I actually wondered about the late 60s to early 70s moment when it was at least possible that wealth would become a suspect category. And what did it mean? And that was all around school finance. It was all around children's issues. And what, in a sense, there is one might say, a third tradition or a third possible paradigm that we haven't talked about, which was the possibility of wealth becoming a suspect category in constitutional law, which is slightly different than the model that Willie and Joey would develop, but would speak directly to the problem of a care economy. And so I guess I wanted to just raise the sort of idea of sort of how far should, not to sort of think of this as a dyadic story where there's one choice or there's another choice, but that we actually live in a world where the paradigms have broken down, but we live with a political economy which requires care in so many dimensions. And we haven't thought about that. And I'm not sure, this gets back to Paul's point, that the constitutional imaginary is at the moment rich enough to sort of incorporate those possibilities. So I'll stop there.
Great. Well, I also want to give my thanks to the organizers and for the invitation to be part of this great conversation. I'm really happy to be back in Berkeley today. I love this book as well. I think it's incredibly well thought out and researched and just a pleasure to read. So thanks to you all for doing this. So the question that was posed in the title of the panel is, should we constitutionalize political economy? I guess my answer is a yes and. Yes, we should constitutionalize political economy. But I also want to, I think, take up some of the themes of already about the we, which is in some ways the audience question, and in some ways kind of the question of who are the actors as we think about this. So, and I want to meditate a little bit about what it means, especially for those of us who are in academia, and especially those of us who are in law school, to constitutionalize political economy in a time when teaching and learning about political economy is under attack. So we all know the facts that for the past 3 years, the Republican Party has campaigned and governed on a platform of censorship. We've seen over 600 local, state, and federal bills that are designed to chill basic conversations about racism, about sexuality, about gender, about reproductive rights, and other topics in the classroom. We've seen thousands of book bans, most of which target stories focusing on minoritized or subordinate. We've got kind of an explosion of school district policies targeting anti-racist pedagogy and curriculum. And at the same time, we're also seeing historic rises in hate and harassment, hate crimes against Asian American folks, bomb threats targeting historically Black colleges and universities, spate of attacks on synagogues. And of course, we know about the continuing war, competition to double down on anti-abortion laws, even though those seem to be incredibly not publicly popular. So it's tempting to file these and related actions under culture war or moral panic, to see them as pandering to white nationalism, evangelical Christianity, or simple fear of difference. But with the lens that Willie and Joey have given us, we can also see this project is very much about political economy. In December 2022, when Florida officials appeared before a federal judge to defend Governor DeSantis's decision to suspend a local prosecutor whom DeSantis had termed a woke ideologue, the judge asked DeSantis's general counsel to define woke. And the answer was that woke is, quote, the belief that there are systemic injustices in American society and we need to address them, right? So if you take that in for a second, the attack is not only on people from stigmatized groups, it's not only a so-called culture war, it's not solely an attack on speech or ideas that require the standard First Amendment responses. The attack is really against the project of this book, right? To recognize and articulate a forgotten national constitutional democratic opportunity. In other words, to recognize that there are systemic political and economic injustices in American. Okay, so Joey and Willie ask us to define broadly. So they make clear they're not about, this is not a project about relying on the Supreme Court to make things right. They're well aware of the successful attempts of the right wing to shape the judiciary in a pro-oligarchy direction. To constitutionalize for them rather means to bring actors other than judges, especially legislators, politicians, Congress, into constitutional thought and debate, as well as to promote this idea that there are policy forms the Constitution requires, not just permits. And throughout the book, there's great examples of how we might do this differently. But to accomplish this, I think those of us in law schools also need to reconsider how we teach the Constitution and how we situate law within political economy for ourselves and our students. And more broadly, we need to consider how we engage with the plethora of social movements who are also already playing political economy. So, we a few minutes ago, we were talking about the way in which there's been this extraordinary policy shift in terms of climate change, many other kinds of policies. In large part, that's not because elites have pushed out ideas, you sort of pumped out alternatives to neoliberalism, but it's coming from the bottom from the grass tips. It's coming from movements like Black Lives Matter. It's coming from climate politics. It's coming from justice movements like those around land justice, economic justice, and water justice. And it's coming from the labor movement. Right? And so maybe what I'm gesturing towards here is the notion of popular constitutionalism, or what Amna Akbar and her colleagues call movement law. But how do we link the project that's being proposed here with the energies that are bubbling up from so many other places in our polity right now? This energy to around thinking about political economy, about what is a fair distribution of democratic opportunity, what are whether capitalism is even a good idea, what does work look like? All of these questions are really at play in civil society all over the place. And how do we link what's the energies that are happening there to the movement here? So those of us who are doing work that we identify economy, I think are creating some incredible new scholarship. But I'm not sure that producing good scholarship is enough at a time when our students who come in will soon be learning less than ever about their own history. And at a time when even to discuss structural inequality is being attacked is inherently ideological and liable to hurt someone's feelings and therefore not permitted. So to constitutionalize political economy in this moment, examination of our conventional academic theories of change. Are there ways to better and more systematically teach our students about the rich history that's conveyed in this book? And I think it was Larry's point about writing a version of the book that's like much thinner. A friend of mine who's a historian has turned to writing graphic novels about the history of slave revolts and bringing her research into a completely different kind of format in order to capture some people who might otherwise not engage. There are people in this room who are superb public intellectuals and movement intellectuals. This sort of bridging works superbly well. There's models for different kinds of initiatives, whether we're talking about justice-focused clinics or we're talking about things like project-based learning. But these brilliant people, initiatives, and projects are generally laid on top of business as usual, sort of existing curricular and scholarly practices and norms that continue to reward individual brilliance rather than collective action, and continue to rely on elite power in order to make things happen. Sort of the ordinary channels of we have good ideas, we convince people in Congress to enact them, and that's how change happens. Yet all of this is happening in a crisis of knowledge production, exchange, and dissemination. So how might we think a little bit more deeply about transforming these great ideas, these individual projects and initiatives into institutional and structural frameworks where there are more opportunities for engagement institutionally and structurally between civil society initiatives that are, again, really and deeply engaged in political economy and folks in the academic world who are doing the same. And I think I will leave it there. Thanks.
Well, thanks to all of you. This is a terrific set of interventions, and I'm so excited to be in this conversation with all of you. And thank you also to John and for all of the organizers of this for convening it. I'll just say a few quick things, ending with or beginning where we ended. I think Angela's question is just terrific about the question of the relationship between all of the energies bubbling up in the polity about questions of political economy and the kind of project that we're doing in this book and that we're talking about here, which is obviously more academic project. This is the third of these gatherings, and we did one in Washington that was more political in a way. We talked with a lot of Hill staffers and think tank people and people who are kind of doing DC politics anyway, that kind of politics. What they were getting out of our work, it was interesting because, it was not so much constitutional theory, it was almost a license to make arguments against the court of a particular kind. And I guess the way I see what we're doing in that regard, I guess I would sort of maybe a little bit amend part of what Jonathan Gould's initial intervention framed as a question of framing arguments in constitutional terms versus economic fairness terms. I think in a lot of ways, what we're trying to do in this book, the core of it, is to expand the conception of what counts legitimately as constitutional terms so that it includes some things that might sound like economic fairness terms or that could be framed in various other economic ways. And this expansion of what counts as a legitimate constitutional argument, it was important to us, but also to some of these kind of DC political types, because it lets some arguments kind of into the room as potential arguments to push back against the hostile Supreme Court, arguments that if we maintain this kind of very strict large C constitution, small c distinction, if we maintain that distinction too sharply, then it just leaves the court in charge of the real capital C Constitution, and it leaves all these other arguments out in some other realm, unable to directly respond. I guess so. In relation to part of what Paul said now, I think the purpose of expanding the set of arguments that count as legitimate constitutional arguments is partly to push back against the court. And I will say, over the course of writing this book, which took a long time, as has been alluded to, that strand of what we were doing kind of became stronger with time as the court shifted further and further right as we were writing. I also think, though, that it's important to see constitutional arguments as a foundation for justifying structural reforms of the constitutional order. So what do I mean there? Basically, if you look at the most successful period of constitutional structural reforms since Reconstruction, which is the progressive era of 100 years ago that was so rich with obviously a lot of state level, the initiative and the recall and all the great, Western state stuff that was to make the constitutional orders out here more democratic, but also major wave of Article 5 amendments to bring the Senate into direct election by the people and all of that. When Willie and I were reading what people were saying by way of justifying these structural reforms to the large C Constitution, there was a lot of arguments that, as Dirk notes, there was plenty of disquiet. There was plenty of the Constitution is broken and has problems, but there was also at the same time a kind of we need to reform the Constitution in order to vindicate values that are in it and that are, part of our Republican constitutional foundation that has been corrupted by subsequent, capture of the senators, by the state legislators that have been bought off by the railroad, and you get this kind of reform in the name of constitutional values and arguments. Even Beard himself, as Willie's always pointing out, even Beard does this. And so there's a kind of fidelity-based arguments for structural reform that I think may be important to recapture. And that's one of the things that making a broader set of arguments that are not so clause-bound and so textual, but that bring in Republican ideas, it helps to do that, to help sort of ground your structural reform projects. And it also helps push back against the court. There's one example that I thought might be a useful one to bring of response to a couple of the points that have been made. Unfortunately, I thought about it. It's not exactly a care economy example, although it's related in a certain deep way, because the care economy, part of why it's such a challenging political economy flashpoint is because the care economy runs on redistributive government social provision. It doesn't work without a lot of that. And so when you have a right-wing constitutionalism that is all about anti-redistributive social provision, it's going to undercut and destroy lots of the care economy, as we see in the states that have failed to expand Medicaid and the collapse of the rural hospitals and all of what has resulted because of, purely because of right-wing constitutional arguments that, although supposedly grounded in other places, are actually just the old anti-redistributive constitutionalism of 100 years ago and before. So the example that I thought about bringing up that is sort of all parallel in an interesting way, because it's also the current anti-redistributive constitutionalism, is the student loan cases that have been brought against the Biden administration student loan, which the student loan relief, it's such a great and interesting example of, as I think Paul may have, or one of you brought it up in this discussion earlier, of a kind of post neoliberal. There's nothing more neoliberal than like student loans, returns to capital will fund the education. This student loan relief is now embroiled in litigation that on its surface is some kind of statutory principle about major questions, But the conservatives who are trying to make up that principle are very clear that really this is a constitutional case about non-delegation. That's what is underneath the major questions doctrine. That's why we should have a major questions doctrine, is because Congress shouldn't have the power to let the administration do this student loan relief. So why do they think that? Well, if you really were operating within the kind of second half of the 20th century constitutional law paradigm of liberals, you would think that at the court, they would be making maybe like originalist arguments about non-delegation. They would be, fighting with, the people who've done all this research about how actually there was lots of delegation at the founding, or, something like, or maybe textual arguments, really scrutinizing the words, the executive power, which is the only 3 words on the topic, and, really like parsing those words carefully or something. But that's not what they're doing. It was just straight up constitutional political economy arguments. When you listen to the oral argument in these student loan cases, the conservatives are basically saying, we think the case should come out in the anti-redistributive way that we imagine it should come out, because we don't think it's fair to give relief to students who, what about, there's so much discussion in the oral argument. What about some guy who starts a lawn care business and therefore his loans for business are not eligible for student loan relief? And, there's all kinds of arguments to be had about the fairness of that. But my point, that's what I think is sort of crucial, is that on the right, those arguments are not just fairness arguments. It's not fairness arguments over here, constitutional arguments over here. It's the constitutional arguments are imbued with the underlying economic theory, or as kind of Larry put it at the beginning, the underlying paradigm of what we think about how political economy should work. And this court thinks, as the movement that put the justices on the court argued and got them on there, that redistribution is anathema to the kind of political economy that their vision of the instantiates. And so hence, we're going to have them striking down student loan relief. So when faced with that, I find it somewhat to be an odd question. Should we constitutionalize political economy? It's been done. It's afoot. And the question is, what are the right responses? And when progressives make their own kinds of arguments against what the right has been doing, of course, there are questions about audience and register and framing and how we should say it. But I think it's important to keep in mind the idea that we need to legitimate our kinds of arguments about political economy as being just as legitimate in constitutional fights as the other side's arguments about political economy already are. Because otherwise, it's just a very one-sided back and forth, where one side says, core problems of and values are implicated by this redistributive student loan thing, and our side says the government is permitted to do this. That's just such a weak response. So anyway, I would love to respond to more of it, but I want to open this up. So I'm very eager to hear more of your questions and reactions. Thank you.
Great. Let me ask one brief thing by way of follow-up, and then folks should raise their hands or catch my eye. And it's a contemporary point and a historical point. The historical point is around the Great Society, which seems to have come in the midst of the Great Forgetting that you described. Yet despite that, we got Medicare, we got Medicaid, we got other war on poverty programs. Would love to just hear a word about that. And I guess the contemporary resonance, I'm so thrilled you brought up student loans. I think it's kind of one of a panoply of issues. But I think who are the most important anti-oligarchy progressive thinkers about Bernie Sanders and Elizabeth Warren and Alexandria Ocasio-Cortez? I don't think any of them talk about the Constitution much. And I'd be curious to hear, am I misreading them, or do they talk about the Constitution? Is this a critique of how they're doing their advocacy? And I'd be curious to hear on each of those.
Great. So first of all, I think as a sort of a footnote in our intro suggests, we see, especially Bernie Sanders, who talks so much about oligarchy as doing a kind of constitutional argument that because we have such a court-centered constitutional order at the moment, we don't always recognize what he's doing, and Warren too, as constitutional talk. And so part of what I think we had some Warren staffers at the DC event who were, I think, almost engaging on this issue. Partly there's a question of what counts as constitution talk. And I think it's important to have a pretty capacious view of that. This is all part of the project of breaking down the sharp line, historicizing, and then breaking down this sharp line between large C and small c constitution. I see a lot of what the three people you just mentioned are saying as, to varying degrees, depending on exactly what they're saying, implicating and sometimes straight up invoking, as in Sanders' talk of oligarchy, arguments that for most of our history would have been seen straightforwardly as constitutional arguments, and that probably it would be helpful if we again saw them as at least continuous with a spectrum of constitutional political economy arguments. I see Willie wanting to jump in.
Just a quick, Bernie talked about little else but the Constitution in the Starbucks series about
That's true.
the sort of the struggles of the Starbucks movement for union. So it's sort of, it is not the case that Bernie is not on, sort of grabbing hold of this tradition. He was sort of, I think I can more or less quote him as saying, every worker in every sector in every state of the US has a constitutional right to organize and strike. So I think as the sort of what Angela talked about, bubbling up from social movements, sometimes just self-organization of workers, sometimes union people. It was a union person from the Teamsters who kind of came up to me a couple of weeks ago and at the Law and Political Economy gathering that I was at, saying the folks who are saying Bernie doesn't talk about the Constitution aren't paying attention to Bernie. So I think in that space, and in the space of Medicare for all as a right, that is Constitution talk. The idea that there is a right to health care was at the heart of the sort of New Deal constitutional political economy, and it's bubbled up again.
And some of that,
but I won't say
no, sure. And some of it's easier to see it when it has a rights frame, and that's why labor is perhaps the paradigm place where we see it most, or it's the most obvious, But I don't want to take too much time, but I just briefly regarding the Great Society question that you posed, I think it's really interesting. I mean, one of the things that Willie and I struggled with in writing that part of the book is we don't want to downplay the tremendous achievements of the Great Society, and in particular, the focus on poverty was kind of a first in American history, as opposed to a focus on the middle class constitutional arguments that we see so much earlier. And of course, a tremendous amount of political economy intervention came out of. But there were major limitations as well to that project that were related in a deep way to the rise of a kind of economic vision within liberalism in the second half of the 20th century that removed a focus on both the middle class as a whole and on a kind of power inflected, let's build up the power of labor against capital. That kind of New Deal thinking was gone from the picture in a way that seems like clearly a problem. And the timing of the Great Society as at kind of the end of this, amazing post-war period of compression, less inequality and lots of good jobs as the United States, exported everything to the world. The timing turned out to be to expose soon in the 70s. I mean, this is Jefferson Cowie's work and a lot of people that, it became clear that the areas where the arguments of the Great Society and the program building that they were doing had not actually pulled together the kinds of political economy visions that people at that time, like Coretta Scott King, there's people in the book actually who are making the case that you needed to think about full employment if you're going to do fair employment, that you need to really be intervening, that sort of mainstream liberalism had kind of moved on from and was not going to do by that point. That turned out to be a really prescient critique. And so we want to embrace that in that part of the book and the prescientness of that critique, while also not completely, trashing the greatest moment for second half of the 20th century progressivism. So it was an interesting line to walk.
Right. Well, in the anti-oligarchic spirit, we should open up. So Katie Albiston, please. I think because we're recording, yeah.
I had a comment and then a question. So one of the themes that's come out is the idea that the ability to strike things down on constitutional principles inherently favors the right. And I think you have to take into account who's the enemy, right? Because the ability to strike things down was really important for government overreaching. And I'm all the poverty victories that were made in the 60s and the 70s about the rights of benefit recipients by legal services corporation lawyers, who then, of course, were the target of all kinds of difficulties themselves. So, and there's Eighth Amendment cases that we could point to. So I think the ability to strike things down can be helpful if the enemy is the government, but it's a problem when the enemy is market or market actors. So that's just one comment on that. The second thing that I wanted to bring up is sort of the crazy world of the corporation, which obviously there's a history that people kind of brush aside of the corporation as being a government created grant that originally had a public purpose, and then it became kind of more democratic to let everybody create corporations because there was this concern that government was only giving this special grant to powerful businesses. But now we've come all the way back around to the point where the corporation is a person, just like, or I would say not just like, the rest of us. But Congress is now trying to restrict the ability of corporations to consider anything except economic interests in this regulation of socially conscious investment, right? So there's a kind of inherent, what do I want to say? Hypocrisy. That's kind of overstating it, but the values behind the corporation and the privileging of economic values of other values, even when corporations do it in part in response to social movement action, seems like a perfect target for this sort of values-based argument, right? So to push back against the Milton Friedman, all that matters is the shareholders and profit argument, is to point to corporate actors and say, look, they have a right to free speech too, and they're responding to democratic efforts on the part of social movements to push them. Who are we to restrict that? And yet I'm not seeing that argument. And maybe that's a fear of, shoring up Citizens United or whatever, but it seems completely incoherent as a values argument and a place in which maybe we could push on that a little bit more. So, okay.
Yeah, please. Yeah.
I just want to make a shout out for my colleague Margot Canaday's new book on queer careers, in which basically the reason why work for queer people around the country change is because of corporations, because they're under pressure and because corporations changed. The government actually was laggard in every possible way, and that's the heart of Margot's book. So I just wanted to say, an interesting political economy moment around the sort of change in the labor practices and the work lives of queer people is sort of marked by Margot's book.
Floor is open. John Powell.
Thank you for a good panel and Jonathan and others for bringing us together. Something I've been noodling on, and I just reread part of Fonner's book, The Second Founding, and also I think of Alamar's work in the Civil War amendments or Reconstruction amendments, and the provision in those amendments that empower Congress to enforce those, which wasn't in previous amendments. And what Aquilamar and to some extent Fonner argue is that Congress is a co-equal branch with the Supreme Court in terms of interpreting the Constitution, especially under those amendments. Now, one might think, given who Congress is, you don't want Congress to have that power, but it does suggest in terms of the focus of who should interpret the Constitution, who should have the final word. Should it be the court or should it be representatives of the people? And when you think about the court striking down things like the Voting Rights Act, I mean, it wouldn't be allowed under that kind of provision. And so I've been thinking about part of a new constitutionalism or constitutional economy would actually be to push to create a constitutional crisis by saying to the court, you don't have the ability to usurp this decision. This is granted to us by the Constitution itself, and talk about the failure to actually, I mean, to me, that's one of the most potentially radical things in our Constitution. And it could correct some of the things that Paul mentioned in terms of the Constitution being conservative. I feel like we keep forgetting that these three amendments were really potentially quite radical, but the court largely on its own just stripped them of their radical implications. So I just wonder what your thoughts are about that.
Yeah, I'll jump in after. Yeah, please, David.
Just to say, although the amendments that Professor Powell makes reference to have an explicit provision for Congress, in general, this is the old ideology of departmentalism, which is to say all the branches are co-equal and all the officials who swear to uphold the Constitution have in some sense an independent and autonomous duty to uphold the Constitution. And you know, on that view, which I find it an interesting view. I don't know what to make of it, but you know, it's tied in with Marbury v. Madison being État, and the Constitution in some sense being a common culture which doesn't have a decisive point of interpretation. It's not a surprise that progressives are now attracted to departmentalism without realizing, maybe without wanting to own it. But I first came across it in Edward Meese, who was Ronald Reagan's Secretary of State, who was a strong departmentalist in the 80s, that the various governors and so on would have an independent right not to uphold federal. So, this is just to raise the stakes of the question, which is to say, we're now in a moment where oddly progressives are becoming departmentalists, whereas departmentalism was the great bugbear of a previous generation of progressives.
Yeah, I certainly agree with all that. I think there are two things going on here. One of which is in the aftermath of the civil rights movement, I think progressives who want to embrace departmentalism have to, with one side of their mouth, argue that the federal government is supreme vis-a-vis the states, and the court is supreme vis-a-vis the states, and Brown was right and Cooper was right, and kind of elevating the courts vis-a-vis George Wallace, while simultaneously denigrating the court vis-a-vis the elected branches of the federal government. So I think there is this kind of conflicted progressive attitude toward judicial power that is, for me, part of the kind of long shadow of Brown and the shorter but important shadows of Roe and Obergefell and other progressive victories. So I think that's part of the story. The other part of the story, I'm very attracted to a story of kind of congressional constitutionalism, good work being done there. I think it runs up against some of the things that Paul was talking about, that in a world of a president who often doesn't win the popular vote, of a malapportioned Senate, of gerrymandering on the House side, of a campaign finance ecosystem that we live in, how good do we feel about empowering Congress? And my answer is often better than the other two branches, but still not allowing me to sleep especially soundly at night. So I think I think it's a really critical suggestion. I think those are kind of two complications that perhaps help explain why folks haven't embraced it as full-throatedly as they otherwise might.
Yeah, just to jump in here also, I think I completely agree with Jonathan Gould that the more legislatively centered constitutionalism of the progressive future, it's going to be very challenging to get that progressive Congress into place, but that it's still the best of the alternatives institutionally. And I think to kind of go back to KT's question and weave them together. I mean, one of the things that was really striking that I hadn't known the fullness of until working on this book was, 100 years ago, progressives, many of them were fully ready to shut down judicial review. I mean, proposals for how boldly to confront the court were much more radical than anything today or anything that I would be frankly comfortable with. And that's because this was before liberalism, I mean, the victories of liberalism that yeah, right. I know. That's the thing. I mean, it's the court is having a radicalizing effect on everyone in different directions. But I think there's now an edifice of liberal decisions, including the Eighth Amendment decisions that I'm glad you mentioned, because the thing about criminal justice is that, it's very hard to get popular majorities for, let us give some rights to the most despised people. That's, one of the hardest political nuts to crack. And of course, it's a place for liberalism. But I think, a lot of the story of the book, as I see it, is in its contemporary implications, is kind of a story of legal liberalism did a lot of good things, but had some real limits in addressing political economy. And when we start to go back to this more progressive vision of how to do politics, that is less, involved with court-centered rights claims, then we end up embracing an older configuration of institutions too, which I think we need to shift the balance somewhat toward. I would like to see the congressional kind of instituted constitutional crisis that Professor Powell is imagining. I think that a lot of groundwork needs to be laid if the people are going to be broadly on the right side of such a crisis. And laying that groundwork is going to involve making a lot of political arguments, the crafting of which, I don't know exactly how to do, but to build the political base for arguing that the court and its constitutional arguments are wrong. So I think that's part of what we're hoping to.
But I could just say one thing. I mean, one part of Professor Powell's point, which is exactly right, is of course this happens after Dred Scott and after a civil war. Without this, do we need? We may have the Dred Scott. We may have the is Dodds going to be our Dred Scott? I don't think so, but I don't know so. But we probably don't want the Civil War as a precursor in order to justify that kind of freedom.
Can I ask a question? So in the book, there are a couple of spots where you kind of pinpoint the rise of economics as something, a discipline that places political economy and sort of pushes some of these questions about, the Federal Reserve and money supply and out of the realm of popular discourse or public discourse and into this specialized realm of technocrats. What should we do about that? I mean, is there a project there for those of us who want to promote progressive political economy or the tradition of democratic opportunity? How do we confront this sort of technical specialization and kind of elevation of economics as a discipline?
I'd love to hear what anyone on this panel or Willie has to say about it, but I think there are a lot of projects in there. not just a project. I think there's, I think part of it, one set of actors who can do a lot of useful work is political leaders, because and Elizabeth Warren has done some of this, and so other sort of progressive political leaders, just by making arguments about what monetary policy should be that sound different from, just follow the technocrats. That helps give license to people out in politics, elsewhere to make those arguments. But anyway, I think there are many projects that are needed to sort of assert that that we, the people more broadly than a few experts, have a lot to say about this. And also, I think there's good work to be done from within the towers of expertise to open up the doors and say, actually, there are political choices here. And I think there are people in economics with a sort of LPE or the political economy interest and orientation who are beginning to do some of that too.
Yeah, I mean, Brian Kettering is here, so he could speak directly to this. Since my sense is that this is exactly what the Hewlett Initiative is about: is not trying to supplant. Like, economics is really important. There's a lot of extremely valuable, but economics, the profession, should not have a monopoly on discussions about what a desirable economy looks like and how that fits into a democratic society. And there are a lot of people who have things to say, valuable things to say about that can actually make economics more interesting and more broad-minded as well. And I think so a lot of that work is going on now. I mean, I think at least within the academy, but I think a lot of people who are trying to expand beyond the academy.
Thanks. Yeah, thanks for the book and the discussion and all that. I really enjoyed all of it. And I've enjoyed this project for close to 20 years now, since Goodwin Liu gave me that old Michigan Law Review article that's, I guess, about to turn 25. But I wanted to, so there's a concept, one of the early articles in this project was the New Deal Constitution, and the idea that the great forgetting about this progressive constitutional tradition. But I also want to talk about the other side of it, the forgetting of the political economy, the progressive political economy tradition. And I haven't spent as much time with the book yet as I'd like, but I saw that there was some discussion of McCarthyism and the construction of kind of like Cold War liberalism that excluded a lot of the progressive thinking. And so I wanted to put that on the table, because I think we are still at the beginning of reviving the progressive political economy tradition in the United States, especially. And, of course, political economy traditions persisted across all the disciplines. And I think we're now in the process of kind of like bringing those people back together in conversation. And so just as we have to remember the progressive constitutional tradition, I think also we're kind of at the beginning of remembering the progressive political economy tradition. And I would just also add, we were talking about certain key people in Washington, Bernie Sanders, AOC, Elizabeth Warren, but also we should think about Occupy Wall Street, I think. I think that was really a seminal event for putting these issues firmly in the public discourse in a way that in ways that were surprising to me, that they were not able to be pushed back out of the center of all this. So I just wanted to say that we should also be thinking about the political economy side of this. And, we're at Berkeley, where Berkeley is kind of a unique place for having so many political economists from so many disciplines to talk with about these things. But at a lot of schools, that's not the case still. And I think if you go and talk to Capitol Hill staffers, how many of them actually had a strong political economy undergraduate? Probably not a lot. And that's true of many other institutions in society. So I think, both sides of this project, we still have a lot to do. So thanks.
Thank you very much for enjoying the conversation. I wanted to bring history back in, because it seems to me one of the most important parts of this book is that it's a history that history is what constitutes us, not the Constitution as a piece of paper. At least that piece of paper needs to be infused with history. And I'm thinking about, Angela's point about the right's mobilization around critical race theory. Why is that? Or what does wokeness mean, except acknowledging our history and taking from that history a constitutional mandate to do something about that history? And, thinking about the Reconstruction amendments and the way that, the first desiccation in a way of the Constitution by the court was really in that period, destruction of the clearly radical potential of that. But, I think one of the things that's so threatening to the right about, quote, wokeness, and I think we ought to defend that term or reanimate it, because it speaks to the deep Christian roots of this, social movements in this country that have had an impact. So yeah, history. I was struck that, maybe the phrase should be, should we rehistoricize, the Constitution or the battle over the Constitution? Briefly on I was struck by the mention of the Great Society, because not only is it sort of the last moment where kind of political economy in a broad democratic, small d democratic sense was being debated in Washington and moved, but because of the malfeasance or misfeasance of Lyndon Johnson, the court was pushed to the right in a way that, had Fortas and Goldberg stayed on the court, had the Warren retirement not been mismanaged by the administration, et cetera, had Robert Kennedy not been assassinated and gotten to appoint the next several justices, we would have had a court that might have implemented a great deal of the sort of radical political economy ambitions that we're talking about here. So there's that moment that's interesting. The other moment to me that I've never quite understood, and I'm hoping some of our historians could speak to, is the eugenic period in the 20s. The Constitution was amended to prohibit alcohol, which is, one of the most popular items on the planet and has been historically. And then they amended it again to repeal that. I've never understood why they even had to do that, since Congress had the power to either implement law or not. But are there any lessons from that side of the progressive era, that they seem to be able to deal with the Article 5 obstacles in a way that shouldn't have been possible, given how controversial the basic politics of that were? So those are my thoughts for the moment. Willie, did you want to hop back in here?
So Joey and your mention of sort of remembering, and Angela's question about how to both acknowledge the sort of that you need experts to run an economy, and yet banking, currency, and credit sort of are too important to leave to experts or economists. And to historicize the question, the late 19th century saw, broad publics engaged with the question of how should this banking system work? What is credit for? What is currency for? And they made, textual arguments about how the Constitution, right, sort of authorizes Congress to regulate credit and currency. It doesn't, right, authorize Congress to, right, franchise that out to private actors, so that there was both a sort of, neither better nor worse than many textual arguments, an argument that this was a kind of constitutional wrong to impart to, private banks or a national banking system that ultimately was controlled and designedly controlled by private banks, was a usurpation, that you needed public control over banking and currency. And and that in turn, that should be used to underwrite equitable development across the country. That movement's been revived in a robust way, with some great deal of historical self-consciousness. Well, and there are interesting, as Paul suggests, important debates about the role of the Fed, whether, as people like Bob Hockett says, the Fed should become a jumbo development bank, right? In which, the allocation of capital, the nation's capital, should again go towards these social goals. Or whether, as people like Lev Menon suggest, the Fed isn't, has to do certain kinds of more narrowly honed work about controlling sort of inflation and so on, but that you nevertheless can accompany that with, again, robust development banks that are publicly controlled. And Congress people shouldn't have to write op-eds urging the Fed, right, to think about Black unemployment. And we shouldn't be afflicted by it here, what is breathtaking to me more than anything else about sort of the liberal media is how they have bought into, how listening to NPR and reading the New York Times, you would think there are precious choices, but to either boost, either sort of allow unemployment to rise again, right? Or sort of suffer inflation. The idea that there are no other ways to address, sort of inflation, no other ways, or that the deficit is sort of per se a problem, is this kind of shrunk imagination that would have flabbergasted 19th century progressives and right-thinking populists. So I think, and these were all deeply constitutional. I'm kind of taken aback by the idea that sort of addressing Dobbs and abortion and healthcare through a constitutional lens seems ill-suited to the popular mood. I kind of think the popular mood thinks that these are rights, and I kind of think that a sort of constitutional politics that is neither exactly small c nor big C is where ultimately the more formal constitutional law will sort of in a better world take shape. And that's the gist of the book. I think that what happened to the idea of wealth as a suspect category, that was a movement that was about basic income, but not surprisingly, legal liberals only succeeded far enough to get a right to a hearing, right? And the broader idea is afoot again, and it is a way to address the care crisis.
Alvin, David.
Yeah, so I'm really glad you raised Dobbs, because I think if we're trying to understand the politics of all this, it's really interesting to think a little bit about Dobbs, which to me is a clear example, right, of where public opinion has responded quite negatively to activity from the court, and it's produced a backlash, right, and produced things like the Wisconsin election a couple of weeks ago. But I think for this conversation, it's worth really puzzling over that, because on the political economy side, I think you see nothing like that in the history of the last 40 years, right? I mean, I think you guys lay out extremely well what the court has done on issues of political economy that just, profoundly affect people's life. Arbitration, binding arbitration is just one of, we could give 50 examples in this room. None of that stuff resonates in public opinion in anything remotely like the way that Dobbs does. In fact, when most people talk about, if you follow in the media, conversations about the conservative term of the court, it's overwhelmingly about the social, not about the political economy, right? Those get very, very little attention. And I think they don't resonate in public opinion in the same way. And I think part of the reason is it's just too complicated. Like, policy is really complicated. And in most cases, connecting the dots, once you start getting into conversations with people about procedure, right, and about legal procedure, you've lost, like that is not the way that you mobilize. And so, Dobbs, I just think very clear, very immediate. It's clear who the decision makers are, and what consequences that is producing for real people, right? And I just think the whole realm of constitutional political economy, at least narrowly, I mean, once you say, well, talking about oligarchy is constitutional political economy, then okay, fine, right? But if you think a little bit less capaciously about it, I'm not sure what it means to think that capaciously about it, honestly, right? If you think a little less capaciously about it, I think you lose the audience, right? And that's the problem.
Just a few quick thoughts, and I also have to apologize. I have to run it in about 5-10 minutes. I'm going to run out to I have a grad student exam, so I apologize. It's not anything that's anyone said on the panel. I just wanted to come back to note that the previous two comments, Willie's and John's, we keep circling back to the role of judges and in some sense the composition of the court and what actors might be able to somehow influence it. I just note that. And if we expand it to being about legislation, then it's not obvious why we need to have a constitutional imaginary doing the work as opposed to present-oriented values. We can call them constitutional in a kind of British sense or constitutional imaginary, but I remain, even after this really interesting panel, a little unclear exactly on the relation of constitutional law to organized democratic politics. And what I wanted to say at the beginning was that there are basically two models in the history of antiquity, and I think maybe in the present. One is the Roman model, where you imagine that there's this thing called jus that hovers in politics and is the ground. And then the fight in those societies is over who gets to control jus. And in Rome, what happened was that there was a struggle from the lower orders, and they slowly took control of the command. And they got in some ways, more egalitarian social distribution of wealth over time. And eventually they found that the apogee of that system was the person who, the merger of executive power, the ability to enforce the law, with jus, the ability to declare the law, a very natural teleology. Then there was the Athenian model. The Athenian model was that the only way to deal with this thing that hovered behind and the priest said was the meaning of right and what the gods thought we should do was to democratize it by bringing in the control of law into large citizen jury panels. Those are two models. Rome falls from within based on its own teleology. Athens falls from without based on something that its own laws couldn't control. The United States hovers in between.
Oh, sorry, I didn't see the mic in my, wow. Why don't we go here on the left, then to the middle.
I was just going to say very quickly that I do think that there's a way in which the politics of the court or constitutional politics tends to figure less saliently on the left than it does on the right. I agree that some of these more technical questions of constitutional law are not necessarily easily available for public consumption on the one hand, but I also think the left has made the mistake of poo-pooing courts and the political economy of law in people's lives. I don't know that that's been a project on the left on the way that it has been for the right. So I'm not sure then that there isn't far more work that one can do with respect to constitutional politics with a capital C in everyday politics than has been done before. I just don't think that we had enough of that, whereas the right, meanwhile, has made it a political project to translate constitutional politics with a capital C into ordinary politics. So I wouldn't give up on it. I just don't think we've done enough of it.
Yeah, I hope we're going to talk a lot more about that this afternoon. I just wanted to pick up on something and say, there's, I think Paul's fair in saying, where has constitutional political economy been? Because after all, the results are crucial in determining the effectiveness of a discourse. And we've talked about, what kind of arguments help build power. You raised that as a point. And Angela highlights that a lot of the talk about constitutional political economy continues to rely on elites, basically. Policy intellectuals develop policy proposals. Do you argue about them in constitutional terms? Do you argue about them in fairness terms? Is that the same thing? And you bring them to legislators, and legislators either enact it or don't. And so Angela says, well, we got to bring in the people. An anti-oligarchy constitution is totally about bringing in the people. What happened to the working class? That's my question for the panel.
does anyone want to jump in on? We could do several panels on each of those questions, but Angela.
I just wanted to say that you are going to be on a panel with some other folks that I hope will explore this question a lot more deeply.
Yeah.
Well, I think that question is an important one, and what I'm kind of free associating to is a group of professors that have come together in response to the attacks on critical race theory and have been talking about how to respond for the last couple of years. And one of the ideas that's kind of bubbled up that galvanized the group is we should all be joining unions. You were talking about your own union, and it's being on strike. And it's interesting that part of, as we're trying to think about how to counter this kind of right-wing narrative and right-wing project, one of the ideas that's bubbled up is like, what if we start thinking of as workers, us in the academy, that is, and that is one way to make stronger, clearer connections with labor movement folks and with working people, and to understand the political economy of our own methods of knowledge production and dissemination in maybe a different way than we're used to. I think responding a little bit to the elite question of how do we think about how change happens. And so, but I'm looking forward to hearing what you're later today.
We have Paul on this point, then you on the court's point. Great. So Paul, then Joey.
Yeah, just really quickly. I mean, I think it's a great question, and at least one part of the answer, what you would want to explore there is that that a large and growing part of the white working class in the United States has actually, at least in electoral terms, has become enlisted in this project that you guys are decrying in the book, right? So, and that's not just true in the US, that's happening in a lot of other countries as well. And so I think it would be, if one's thinking about how do you generate political power and how do you kind of try to revitalize economic progressivism, recognizing that reality and thinking about what the right political strategies are to confront that would be central to that.
Before we go to the courts, could we stick with 30 questions?
Yes, please. Yeah, Willie.
So, forgive me. Jake Grumbach, Paul Fryer, and others have done, important, rich work about the extent to which unions make the difference between whether white working class in general and white working class men in particular, but not only, make the move to a kind of ethno-national sort of Trumpist politics, or or don't. And so if we're talking about power building in the service of progressive economics, rather than starting with court reform, we should start with promoting unionism. There may be other vehicles for building up a base of political support for progressive transformation, but no one's been able to identify it. And so sort of reinvigorating, rebuilding union power, not only because workers need representation in the workplace, but in order to sort of restore the kind of clout workers had and then amplify it, workers had in the mid-20th century to shape the whole gamut of social and economic policy. I think there ain't nothing like a union, to quote a famous song. So I think that's sort of a power building element. And unlike the labor movement of generations ago, the labor movement is on the right side of race and immigration issues, or at least the progressive elements of the labor movement are. And you all and people on the panel this afternoon will know more than I about the more fine-grained questions of how best to do that and what forms of worker association suited to this economy, and how much one can do at the state versus national level. But restoring, sort of a broad kind of class identity for strong actors in the US, political scene seems, if you don't do that, the game's lost.
So weaving together this power building theme with actually Devin's earlier intervention and question, which I think is exactly right. I think there's an interesting puzzle for those of us on the left when we look at the popular constitutionalism of the right, which has been so successful in, for example, I just think about the gun rights movement and the way that it got the Second Amendment to become what it is today, and the way that it got our gun culture to be the way it is today, which are deeply intertwined. And the fact that you had a constitutional argument outside the courts that the conservative justices on the court initially thought was ridiculous, successfully bubble up, and now it's also the law inside the courts, and there's a kind of mutually constitutive way in which the decisions of the court then further fuel the activism outside. It's this amazing thing to behold. And of course, it raises a lot of questions about what, of course, the thing about it is, it's about, as Paul was noting earlier, it's about a high salient social issue. And the justices who have come in on the backs of that movement have then also implemented the Chamber of Commerce's agenda on arbitration and other things that are not high salience political at all. And so the puzzle, the reason I think this is related to Devin's comment earlier is, what does it look like? What would it look like to get to basically raise the salience and understanding of either a democracy issue or a political economy set of issues to the level that it could function as a target of political popular mobilization and create a dynamic of pronouncements inside the court that help fuel activism outside the court. It doesn't have to be the Supreme Court. It could be state Supreme Courts. These dynamics are not easy to capture, but I do think that labor is an area where you see some of it, like in Michigan, there's a fair amount of political and popular politics behind the seemingly inside baseball issue of getting rid of the right to work law that they just did. And then I also think of, Janet Protasiewicz's campaign in Wisconsin that Paul brought up earlier. Obviously, the centerpiece of it was abortion. And that was a right that I think, frankly, out in the public, I think many people who care about abortion rights would be a little bit disappointed if the end result of all this mobilization is sort of like abortion rights. I shouldn't even say right. Being able to get an abortion is good policy, so we should have it. No, I think actually people want it to be a right, and that there's something important about that to those of us who care about abortion rights is that it's a right. I think also, though, in her campaign, as sort of second or third on the list of what she was campaigning about was the sorry state of democracy in Wisconsin, and the malapportioned legislature reached a level of modest salience, I guess is what I would claim maybe in that state's politics. And so I feel like there are potential opportunities. Clearly, people like Elizabeth Warren are trying desperately to figure out how to make, issues like corporations shouldn't just be beholden to their shareholders. I mean, she's pushing it just the opposite way as the current energy in Congress, or some issues about antitrust. You have the amazing public-facing work of people like Lina Khan, in addition to their work inside the government as a kind of potential set of examples. But obviously, this is hard. It's not easy to get complex political and economic issues kind of boiled down and simplified enough that they can become axes of our politics, but I do think that if you want, a politics where working class white people, among many other groups and a broad coalition, but that group in particular that has swung lately in a frightening way, if you want to re-engage that group of people, then we need creative politicians and communicators of all different kinds. Anyone wants to do the graphic novel about antitrust, whatever, they need to do it. That we need a lot of different kinds of communication. Get some of that set of issues to function in our politics the way that guns and maybe now abortion rights function, which is this kind of productive back and forth between constitutionalism and politics.
Yeah, I think this is where, as we move toward a close, I think this is potentially a unifying thread and a point of agreement among many of the last few comments and those of us on the panel, is that it strikes me that many of the examples, not all, there was the Wisconsin example, many of the examples Joey just gave are either legislative or focused on the elected branches, adding Angela's focus on popular mobilization. And to Devin's question, I mean, it strikes me that if the contingencies had looked different and we had a median justice Merrick Garland rather than a median justice Brett Kavanaugh, or we can even heighten the story, a median justice Sonia Sotomayor, may we be so lucky, there would have been a bit of a dog that caught the car. I mean, I know that Dobbs wouldn't have come out the way it did. I knew the abortion case wouldn't come out the way it did. I think we'd see the students' loans case with more deference to the executive branch, but I don't see kind of a court-centered transformative agenda there. One story is because progressives just haven't successfully developed that for a whole structural set of. But the other story, which I'm more attracted to, and I think Joey and Willie would be attracted to as well, is because the full set of issues here just can't be court-centered. That if you want the democracy of opportunity that all of us, by dint of being in this room, are looking toward, that's going to require legislation and political action and movement building and a whole host of things where the court can be an ally. It can be rhetorically helpful. It can nudge things along. It certainly shouldn't stand in the way. We know what the wrong outcome is Janus, certainly. But the right outcome, I think, has to be led in the two elected and on the streets, as it were. So I think I see Joey nodding, which tells me I should quit while I'm ahead. Does anyone want to share a last word? Great. So we have, I think, a 7-minute break, and then lunch will be available. Any other announcements, John, before we break?
No. So lunch will be available in the hall. We'll break until 1 o'clock. So for folks in the room and also participating virtually, you can rejoin us at 1. Thanks.
Please join me in thanking the panelists.